Hi, this is Juan Milanes with the Law Offices of Juan Milanes, 703-880-4881. And today's question in bankruptcy is, what's a reaffirmation agreement? And is it a good thing or a bad thing, or should I sign one? Well, in bankruptcy law, one of the things that you will do is you'll present all of your debts to a U.S. trustee and to the bankruptcy court. And what you're looking for in Chapter 7 is liquidation. It means that you are no longer going to be responsible for any of the debts that you owe, except for the ones that are either non-dischargeable, such as priority unsecured debts, or the ones that you have decided to keep. You know, that you issued a statement of intention that you want to keep a specific debt because it's usually a secured debt attached to a specific piece of collateral. So, for example, if you own a car and that car has a balance of a loan on it, and you decide you want to keep that car, well, if you want to keep it, you're going to have to continue to pay. And so the reaffirmation agreement is an agreement between you and the creditor that's presented to the bankruptcy court for approval that says, I have the ability to pay for this car, I need this car, and I'm going to continue to pay on it and thereby keep the collateral, keep the car. Does it make sense? Usually, it doesn't. Okay? If you are upside down on the vehicle, for example, if the car has a fair market value of $10,000 and the loan is $14,000, well, would you buy a $10,000 car if someone sold it to you for $14,000? Chances are you probably wouldn't. Well, same thing here. Why would you sign a reaffirmation agreement, which is like a new purchase of that car, if the reaffirmation is for more money than the car is worth? That doesn't make sense. Even if it evens out, if it's $10,000 for the car and it's a $10,000 debt, you still have to be careful. Why? Once you get your discharge order, that means no creditor can collect on the debts that existed as of the time that you filed your bankruptcy. But if you've signed a reaffirmation agreement, you're committing yourself in the future, no matter what happens to the collateral, to continue to pay the debt. So let's say that unfortunately you missed your insurance payment on your vehicle and a major flood comes in and it totals your car. It completely ruins the car, and the repairs on the car are going to be in excess of $7,000 and the car is worth $10,000. There's no insurance coverage, so no one's going to pay for that damage. What does that mean to you? It means that you have a vehicle now that needs $7,000 worth of work, but you still need to continue to pay the $10,000 debt on it, regardless of the fact that you can't use the vehicle. So if you have a situation where you have considerable equity in the vehicle, say a $10,000 car, where you only owe $5,000 or $4,000, it may make more sense. But for that, you need to sit down with your attorney, go over the numbers, and make a decision that's a wise decision. Also, you have to be capable of paying. You have to have sufficient income to continue to pay on that debt and show the court that you are in a position to continue to make those payments so that you don't end up in bankruptcy again in the future. This is Juan Milanes. I hope this has been helpful. 703-880-4881.